Adkins v. Children's Hospital 261 U.S. 525, 1923, is a United States Supreme Court opinion that federal minimum wage legislation for women was an unconstitutional infringement of liberty of contract, as protected by the Due Process Clause of the Fifth Amendment. In 1918, Congress passed a law to set minimum wages for women and children in the District of Columbia. As in other cases, the question was one of balancing the police power of Congress to regulate working and living conditions with the right of individuals to conduct their own affairs without legislative interference. Children's Hospital and a female elevator operator at a hotel brought the case to prevent enforcement of the act by Jesse C. Adkins and the two other members of a wage board. The court's decision, by Justice Sutherland, was that previous decisions, Muller v. Oregon 208 U.S. 412, 1908, and Bunting v. Oregon 243 U.S. 426, 1917, did not overrule the holding in Lochner v. New York 198 U.S. 45, 1905, which protected freedom of contract. The previous decisions, he noted, addressed maximum hours. The present case addressed a minimum wage. The maximum hour laws left the parties free to negotiate about wages, unlike the present law, which restricted the employer's side of the negotiation. The court argued that if legislatures were permitted to set minimum wage laws, they would be permitted to set maximum wage laws. Sutherland asserted, "The statute now under consideration is attacked upon the ground that it authorizes an unconstitutional interference with the freedom of contract included within the guarantees of the Due Process Clause of the Fifth Amendment. That the right to contract about one's affairs is a part of the liberty of the individual protected by this clause is settled by the decisions of this court and is no longer open to question. There is, of course, no such thing as absolute freedom of contract. It is subject to a great variety of restraints. But freedom of contract is, nevertheless, the general rule and restraint the exception, and the exercise of legislative authority to abridge it can be justified only by the existence of exceptional circumstances. Whether these circumstances exist in the present case constitutes the question to be answered." Sutherland cited the changes that had occurred in the years since Muller, particularly the 19th Amendment, which guaranteed the right to vote for women. He notes that Muller and other cases had emphasized differences between men and women as justifying special protection for women, but, in view of the great, not to say revolutionary, changes which have taken place since Muller, in the contractual, political, and civil status of women, culminating in the 19th Amendment, it is not unreasonable to say that these differences have now come almost, if not quite, to the vanishing point.